Deputy President.
Okay. I'm not sure whether it was a mistake on your part. You seem to have completed the wrong form. The questionnaire that you completed is a questionnaire for. It's a questionnaire for people who are still applying for judicial appointment, not for judges. You see, there is a questionnaire for judges. Your questionnaire, page 9, it's question 9 of your, it's written, paginated, page 9.
Yes, Chief.
It says questionnaire for candidate for judicial appointment, but the form that I think that you should have used, it's a questionnaire for judges. Well, the reason why I'm asking this question is because some of the question which, well, arising from the question that were put by the Chief Justice, if we had used the correct form, that information would have been supplied, like judgment that we have written, judgment that were successfully appealed against, judgment that were dismissed on appeal. That information is lacking in that form. So it's, I think that using the wrong form did not help you to sort of market yourself.
Deputy President, I looked at the advert. This was my question too. The advert directed us to this very form that I completed. And I wondered, I saw the difference in the forms, but I wondered why. But this was the form that was attached to the advert.
And well, some of the concerns that were raised by my colleagues at the JSC was that you hadn't written sufficient number of judges from which one can assess your suitability. I'm sure it was based on the information that you provided in this form.
Come again, Deputy President.
Well, sorry. One of the concerns that was raised by some of the colleagues at the JSC was that you haven't written sufficient number of judgment which one can use to assess your suitability and readiness to be appointed. And I'm sure that comment might have been based on the information that you supplied in this wrong form, because if you had used the correct form, that information would have been reflected here. Like, I've written so many judgments, I've got so many judgments that were taken on appeal, so many judgments were dismissed on appeal, so many judgments were upheld on appeal. So that information seems to be lacking in this form.
May I again refer to the advertisement? I blame that on the advert because that's the form. The form that I completed is the form to which we were directed.
Good afternoon, Judge Mutali.
Good afternoon, Commissioner.
You know, one of my concerns was, I understand maybe you've completed the wrong form, but the same wrong form that you completed, I'm looking at paragraph 11.1.
Come again, Commissioner.
I'm saying, even if I have to give you the benefit of doubt, the same wrong form, paragraph 11.1, section 2, it says the legal background. Please outline your entire career in law, giving an indication of your principal areas of legal interest and involvement. Then you respond and say C6 above, paragraph 6 above. When one goes to paragraph 6 above, it does not tell us about your areas of law that you know, I'm just thinking that maybe paragraph 6 above, you say you works in the Department of Justice. Those are not the areas of law. I mean, I'm just trying to think because this is not the first time you came in. What happened?
Commissioner Lepo, I was a public prosecutor from 1989. And that's criminal law. Senior state advocates, it's all criminal law, special investigating unit that involves it's not criminal law, it involves giving legal advice. I was a legal representative there who had to channel investigations and give legal advice. And then there was OCJ, the Judicial Training Program, and then as an AJ. I thought that outlines my career path.
A follow-up, I just think you did yourself an injustice by not reading the question, even if it's a wrong form. What you are describing now is what you should have completed and said, these are the types of laws. That's what we want to say, because you are going to the SCA.
I take the point, Commissioner.
Okay.
Commissioner Pillay?
We're here. Both Chief Justice Zondo and President Monimela spent some time taking you through your selection of judgments and why it is that that selection is so important. You know, the JSC sees that as an occasion for you to showcase your capability, the depth of your experience, and the kinds of matters that you've written on. Now, against that, and I don't know if you recall that that was covered in your previous interview.
Yes, I recall that was covered. It was question 9 point.
Now, against that backdrop, you put up the Ndabeni decision. It's the first judgment that you referred to in your application.
You mean, are you referring to the last questionnaire, the last time?
No, this time round. You put up the Ndabeni judgment. I think it's
Are
the
you
first
referring
judgment.
in which?
If you look at page 25, paginated page 25 of your bundle.
Yes, Commissioner.
Now, there's a number of issues that we can raise with the Ndabeni judgment. Let me just suffice to say this, Justice Njali, you put up a judgment that's made up of 6 paragraphs. The bulk of the judgment is dedicated to establishing that the matter is unopposed. And really the only reasons provided in the judgment comes right at the end of the judgment in one little paragraph where you say that the applicant's version is unopposed and there's no legal impediment to granting the order and therefore you grant the order.
Which paragraph are you referring to?
It's the last paragraph of the judgment, it's paragraph 6. So everything that happens before paragraph 6 is just to establish that the matter, that there is no answering affidavit before you. There was a Rule 30 filed at some point, but the Rule 30 was abandoned. You see that, Justice Njali?
Yes, I see that, Commissioner.
So really the only thing in your judgment is your paragraph 6, where you say that there is no opposition, in other words, the matter is unopposed. The only version before you is that of the applicant and that there's no legal impediment to you granting the declarative sought.
May I just comment about the Ndabeni judgment?
Yes.
This is the judgment that went through scrutiny, through the SCA, through the Constitutional Court. I've given my reasons here that if one looks I must have given my full reasons in the application for leave to appeal, because I must have written this one in haste. There is a judgment on the leave to appeal that went through the SCA, and there it was subjected to a lot of scrutiny, and as such, partly overturned by the SCA and then confirmed by the ConCourt.
So all I'm questioning, Judge Mjali, is why it is that you would include this judgment as a sample or as a showcase for you of your judgment writing.
It's a judgment. I must have made a mistake not to include the application for leave to appeal, because that's where I elaborated on these issues. This one was done in haste just to give reasons for judgment. And then when they appeal for leave to appeal, I gave them full reason. And that is the appeal that was taken to the SCA and confirmed. In the reports, you will get the remarks that my judgment was subjected to scrutiny, and the SA found no reason to tamper with my judgment except for paragraph 2 of the order. And the ConCourt went to the same scrutiny and found my judgment to be sound, and there was no reason for the SCA to have tampered with paragraph 2 of my order.
So if I understand, Judge Mjali, you're saying that the real judgment you would have wanted to showcase is your judgment on leave to appeal.
That is correct. I must have, because I did this in haste, maybe I should mention this, that I had no intention of putting in an application this time, but I had to be, at last moment, collate something to be put in after a lot of pressure was exerted on me.
Can I just say this, Judge, these little things, completing the correct form, putting up the correct judgments, they all carry real significance, because when we consider your application, we do it well in advance of you appearing at the interview. So I just wanted to raise that issue with you.
I take the point, Commissioner. Thank you.
Thank